among the spatial relationship creating liability, we would like to discuss the spatial relationship between master and servant to hold the master liable for his servant to following conditions shall be fulfilled. The first one, tort is committed by the servant, and the second one, the servant committed the tort while his master is, and in the direction of his master, acting in the very course of employment of his master. These two conditions derived their strength from the above two maxims which already we have discussed, qui facit per alium facit per se and respondent superior. So, two following questions were raised in the leading case, Amrik Singh versus Union of India in 1973. Supreme Court raised two questions: who is a servant and what is the course of employment? So, the two things raised, one is who is a servant, and the second one, what is the course of employment? And that questions were answered by our Supreme Court in the leading case Syama Devi versus State Bank of India in 1978. So where the fact of the case was that the plaintiff's husband gives some amount and checks to his friend who was an employee in the defendant bank for being deposited in plaintiff's account. Supreme Court held that when the act is committed, the employee was not acting in the scope of bank's employment. Neither the plaintiff's husband obtained any proper receipt. So, whatever the employee did in his private capacity as depositor's friend, so the bank could not be held liable. Prior to this, the leading English case framed certain rules to determine the question who is a servant. The most popular test is the test of control, which means that a person is servant of other. It was subject to the control of such other. But Lord Thankerton found defects of the control theory. Instead, he said that there must be contract of service. So, there must be contract of service between the master and servant with the presence of these four following elements. The first one, the master's power of selection of his servant, and the second one, the payment of wages or the remuneration, and the third one, the master's right to control the method of doing the work, and the fourth one, the master's right of suspension and dismissal. Further, Justice McCann's expressed that for existence of the contract of service, the following shall exist. One is the servant agrees that in consideration of a wage or other kinds of remuneration, he will provide his own skill and work in performance of some service for his master. And the second one, he agrees expressly or impliedly that in the performance of that service, he will be subject to others' control in a sufficient degree to make that the other is master. And the third one, the very other provisions of contract are consistent with its being a contract of service. So, in the leading case, Injable versus Ram Krishnappa in 1969, the Mysore High Court observed that the relationship by master and servant to no extent depends upon the instrumentality through which the selection of the master is made. The relationship comes into existence when the person selected as servant becomes the servant of the master, and then the master becomes liable where the negligence of the servant was in the course of employment. In course of employment implies two things. One is the wrongful act has been authorized by the master, and the second one, the mode in which such act has been done. So it is the general rule that the master is liable for what he has authorized, but also the way it was or has been done. So, in the leading case, Narayan Lal versus Ramesh Manivai in 1971, the Madhya Pradesh High Court held that the master is vicariously liable for his driver who, while taking business of the master, commits accident, but during the time of accident, if the driver is doing something for himself, then the master will not be held liable. And in another most important leading case, that is Anandan versus Amat 2 in 1988, the Kerala High Court made the following observations that if a owner of a car entrusted it to the workshop for repairs, it naturally infer a test driving permission by the owner of the car. If it commits accident in excess of the authorized permission, then it is on the part of the owner to prove he did not so authorized. And in the another most important leading case, that is Roshan Lal versus Karnal Singh in 1980, the Punjab and Haryana High Court held that the said goods truck was carrying a passenger, and in an accident the passenger died in violation of Rule 4 of Punjab Motor Vehicle Rules 1940. So, the employer of the driver was not held vicariously liable.